I want to discuss mediation statements. Before a mediation, the parties usually prepare and submit to the mediator a mediation statement. Most of the time, this statement is what we say for the mediator's eyes only, meaning only the mediator is going to see the statement. In preparing this mediation statement, it's important to ask, what are we trying to accomplish? Now, this is a discussion between the attorney and the client. The process of mediation is voluntary. No one can force you to file one in advance. The client's paying for the preparation of the mediation statement, and the mediator is charging time for reviewing the mediation statement. So why not be strategic in its submission? All too often, as the deadline for mediation statements approach, some prior work product in the case, perhaps a previously filed motion for summary judgment, will get repurposed into that mediation statement. But how does a long recitation of facts, citing to a record the mediator is never going to review, followed up by pages and pages of case law and complex legal arguments, assist the mediator, the neutral, in resolving the case? I suggest being much more intentional with your mediation statement. Perhaps no more than a few pages. Map out well in advance what you think those handful of important points are that you want to convey to the mediator. Draft, revise, and repeat until you have a succinct, informative document. Do not wait until the due date to regurgitate arguments from past filings. Really give thought about what the mediator needs to know to aid your client in resolving the case. Provide the mediator with that information needed to understand the dispute, not to rule on a complex point. Remember, mediators are not engaged to call balls and strikes, but to get both parties to yes. Lay out in that mediation statement how you see your client's strengths and weaknesses, as well as the other side's strengths and weaknesses. Now, this goes against a lot of our training and advocacy, right? To point out our weaknesses, but only if the mediator is going to see the statement, and these are points that will probably be brought up by the mediator at a point in the process where you're being challenged. Why not call it out in that first mediation statement, that first impression, as it can only aid in the process? It can also make for a good talking point at a pre-mediation session. Now, while I do suggest staying away from that long recitation of law, if there is a novel legal issue, include it in the mediation statement, summarize it, and try to leave it to a paragraph. Address any barriers in the mediation statement that might stand in the way of settlement. The barriers are going to get exposed, so why not put them out there for the mediator to be aware of and to address throughout the process, and not necessarily near the end when it may blow up a resolution? Is there some emotional barrier that's preventing your client from looking at settlement clearly? Then call it out. It'll let the mediator ask the necessary questions that'll let your client open up. Is there a cash flow problem, for instance, at the time of mediation? Then call it out. Perhaps your client wants to settle, but the money needed is just not available at the moment. Let the mediator know in the mediation statement, because maybe a creative solution exists. Perhaps instead of paying so much money up front, you agree to use the other party as a supplier for the next few years at a markup to pay down a settlement amount. And consider addressing some of these questions in your mediation statement. What's the plaintiff's potential for recovery? What's that home run number? What's the defendant's exposure? Are there non-monetary goals? What's your client's probability of success? What are the remaining costs to be incurred, whether for expert fees, for trial preparation, or even if you imagine this matter might be taken up on appeal?